Hello to everyone from around the world. Good morning, good evening, whichever it is where you are. I'm Charlotte Valeur. I'm the chair of the Global Institute of Neurodiversity, and I'm delighted to open this two-day conference about neurodiversity and the legal system. It's a hugely important subject that we need to continue to have some focus on. Neurodivergent people are discriminated against from cradle to grave, and not less in the legal system. How society reacts to us impacts very much how we can function as citizens in society. And for some of us, this impact is so disabling that we struggle throughout our life. The legal system is one we can get caught in simply for being different. The Institute of Neurodiversity speaks to neurodivergent people around the world who struggle, and they're rarely anywhere to turn for help, support, and understanding. I'm myself autistic and possibly ADHD, late diagnosed. We have a lot of autism in family as well, so this is a subject close to my heart. The object of this conference is to facilitate an exchange of cutting-edge academic discourse, policy, and practice initiatives with lived experience at the core. The conference will include all areas of the criminal justice system across international jurisdictions, police, practice in court, and the judiciary, probation, prison, parole, and forensic mental health services. Topics will be considered through a lens of lived experience, policy, academic learnings, and practice. The aim is that all sectors will have the opportunity to share lived experience, learnings, and contemporary practice relating to neurodiversity as they pertain to the research field, organization, and all their jurisdiction. It's hoped that this will allow cross-fertilization of best practice models around jurisdictions. All our moderators are neurodivergent professionals from around the world who will add the neurodivergent perspective to the sessions. And this conference would not be possible without the huge work done by a great group of people and organizations, which is UCD College of Health and Agricultural Science, where we have Beth Kilkenny, Blanette Gavin, Timmy Foley, Emily Watts, and also Gemma Larkin, Dawn Slattery, and Nora Silagi. We have NUI Memos with Etane Quingley, ADHD Ireland with Ken Kilbridge, Neurodiversity Hub and Untapped Holdings Australia with Andrew Eddy, and ION Switzerland represented with me. We are working to set up in 12 different countries currently. So without any further ado, I will go on to our first presenter, which is Associate Professor Anna Eriksson from Monash University. She will talk about neurodisability and criminal justice in Australia, challenges and possible solutions. Anna is an associate professor, as said, in an international scholar in the areas of comparative phenology, restorative justice, and criminal justice reform. She's held several Australian Research Council grants that examines the practices and policies of imprisonment in Australia and the Nordic countries, and their relationship with social, political, and cultural variables in different national and international contexts. Professor Eriksson has also undertaken several research projects focused on people with acquired brain injury in the criminal justice system, and she's a leading researcher on neurodisability and criminal justice in Australia. She combines empirical research with interdisciplinary theoretical scholarship and industry engagement that can lead to changing criminal justice practice. We're delighted to have you here today, Anna. Over to you.
Thank you so much, Charlotte, and for the introduction. It always sounds more impressive when someone else tells me what I'm supposed to be doing. Thank you for that, and thank you for the opportunity to speak to all of you, and greetings from Melbourne, where it is evening time. I will, as is customary, share a presentation, mainly for guidance. If that is working. No. Let's try it again. That's the one. Yes, you can, Charlotte, you can see that PowerPoint. I'm just checking with you. Yeah, great. Thank you. So I'm delighted to have the opportunity to talk to you all today about neurodisability and criminal justice in Australia. By way of background and context, for the last 10 years, together with my two colleagues, Gay Lansdale and Bernadette Saunders, also from Monash, I've been researching in the area of vulnerable populations who are overrepresented in the criminal justice system here in Australia. And we have explored a range of reasons why people become stuck in the system. Our initial focus was on populations that included those with mental illness, drug and alcohol dependencies, and the homeless. Often these groups overlap, but it was also here that we came across a significant proportion of people with acquired brain injuries and other cognitive disabilities. This is also a population that often seems to end up in prison because they're unable to pay their fines and because they repeat their behavior. Basically, punishment as we traditionally think of it is not really effective because many people with a neurodisability are not able to change their behavior or the way, in the way that the system requires. Meaning that once they become involved in the criminal justice system, there are very few ways out of it. One of the issues that was emerging during the time we worked on these projects was the definition of neurodisability, a term that we find more inclusive and that captures a range of other kinds of cognitive disabilities. This is a group that is significantly overrepresented in prisons, meaning both that they might commit more crimes, but also that they are over-policed or under-protected, and that the system fails to deal with them in a way that reduces reoffending. Instead, they are stuck in a revolving door. And these are the issues we wanted to examine from the different perspectives within the criminal justice system in Australia, but also internationally. So for my talk today, I'll provide an overview of the overrepresentation, a particular focus placed on acquired brain injury, where we did most of our research, and also on fetal alcohol spectrum disorder, or FASD, as I will abbreviate that. Clearly acknowledging the intersectional aspects of the lives of the people who have become stuck in the criminal justice system. I look at some of the challenges and some possible, at least partial, solutions and ways forward. I'll start with some of the definitions. Many of you might be familiar with this, but they might be helpful to throw on the same page here. Acquired brain injury refers to any damage inflicted on the brain after birth. It can be caused by a range of factors, including head trauma, stroke, disease, infection, substance abuse, and oxygen deprivation to the brain, for example, due to a suicide attempt. The effects of an ABI can generally be described as a decrease in cognitive, physical, and emotional independent functioning. However, symptoms associated with the condition can vary considerably depending on the individual, the severity and location of their injury, and the person's age, among other factors, which is one reason why it's difficult to recognize, diagnose, and know how to respond to. Symptoms can manifest across physical, cognitive, and behavioral domains and may include slurred speech, sensory impairment, pain and fatigue, as well as issues with memory, concentration, insight, and problem-solving abilities. Aggression, irritability, impulsiveness, and lack of judgment may also be present. And these symptoms can often be misinterpreted as deliberate antisocial behavior. The variability of these potential symptoms and the tendency to be attributed to a range of different causes means that the identification and assessment of an ABI is often very difficult. Adding to this complexity, the presence of an ABI is often accompanied by other comorbidities, at least for these people who come in and out of our prisons all the time. And some of these increase the risk of further brain damage. People with an ABI are at a high risk of obtaining this due to symptoms associated with cognitive or behavioral factors, and the risk continues to compound with each injury. Moreover, mental health difficulties and substance use disorders are more prevalent among people with an ABI, either because of the symptoms of the condition itself or the social changes resulting from their injuries. These comorbid conditions can make accurate diagnosis even more difficult or aggravate existing ABI symptoms. Finally, a broad range of social factors, such as socioeconomic disadvantage, unemployment, trauma, social isolation, and homelessness may also impact on the experience of ABI. As a result of these complexities, ABI is often described as a hidden disability, exacerbated by a lack of public awareness around the condition. And I think we can expand that comment in relation to a whole range of neurodisabilities. The prevalence of acquired brain injury among offender populations has only been identified as significant quite recently. Compared to the prevalence of ABI in the general community in Australia, which sits around 2%, studies have found that the range or the prevalence within adult and juvenile prisons range from 40 to 60%. I'll move on to fetal alcohol spectrum disorder. The spelling of this differs. I hope this is acceptable, but I'll pronounce it FASD as an abbreviation. This is also a neurodevelopmental disorder that falls under the umbrella term of neurodisability. So many of the challenges this individual face are similar to those of people with ABI within the criminal justice system. It is estimated that the prevalence of FASD is 10 to 40 times higher amongst particular subpopulations, such as those in correctional, psychiatric care, special education, and children in care settings, when compared to the global general population, where it's about 7 out of 1,000. In relation to prison, international studies have estimated that young people with FASD are 19 times more likely to be incarcerated than other young people. Individuals with FASD often have problems with memory, attention, language and communication, cognition, understanding social rules and expectations, regulating emotions, abstract thinking, decision-making, impulsivity, and so on and so forth. These primary deficits can have complex and devastating effects on an individual's quality of life, and often lead to secondary effects such as poor mental health, substance abuse, early school failure, unemployment, and involvement with the law, both as victims and offenders. In Australia, FASD is a significant challenge, particularly among Indigenous populations, who are overrepresented across the criminal justice system for reasons of colonisation, dispossession, stolen land and language, and systematic disadvantage across a range of areas and over many decades. The neurodevelopmental challenges associated with FASD has the potential to influence a person's journey through all stages of the system, as victim and offenders, as witnesses, interaction with police, courts, and corrections. And I will talk briefly about these now and give you some examples from both of these categories. In relation to police, police engagement and interviews usually require individuals to listen to questions, respond appropriately, and relay details of incidents or events. This involves skills in receptive and expressive language and storytelling or narrative discourse. This can be challenging for people with FASD in particular, and people with acquired brain injury who are commonly impaired in these areas. Such difficulties can result in individuals with FASD being highly suggestive and trying to please their interviewer without understanding the need for factual information or having the ability to accurately recall it. Due to problems with remembering and recalling information, individuals with FASD may confabulate, meaning to make up components of stories to fill gaps they can't remember, which in turn have the potential to result in false confessions or police misinterpreting their behavior as lying or willful deceit. Some people with ABI have a very similar challenge, whereas others might become impatient or aggressive, leading to new charges or denial of bail. Lawyers are not trained to identify neurodisabilities. Some learn during their practice, particularly those who work in legal aid type organization, who tends to encounter most of these clients. But our research clearly identified the need for lawyers to receive training in identifying these clients and then be provided with the information and resources about what to do next. The client might need a full neuropsychological evaluation, and they might need a support person, a court liaison, communication expert, and so on, to support them during the legal proceedings. This should also help the lawyer present any mitigating factors that should be taken into account during sentencing. In court, the cognitively demanding and often stressful and confusing nature of court proceeding can be particularly challenging. People with FASD and other neurodisabilities may lack the language skills required to comprehend the proceedings and therefore struggle to express themselves or understand what is being said to them. This can result in incorrect testimonies or unjust convictions. In some cases, it can lead to indefinite detention, a particular problem in some Australian jurisdictions which disproportionately impact Indigenous youth. In prison, some people with neurodisabilities do quite well, and I use that term very carefully, with a highly structured environment, little need for independent decision-making, and access to appropriate levels of education and vocational training. However, these people are often the one who then fails upon release, facing significant struggles to maintain any parole or community corrections order due to a lack of structure and support, and often re-incarcerated within a short time frame. Other people with a neurodisability fare much worse in prison and are subject to bullying, peer pressure, extortion, and sexual and physical assault. Those who struggle to remember information, including times of appointments, can also be mistreated by staff who fail to understand the reason for the failure to comply. Issues around staff training, underdiagnosis, and a lack of knowledge of actual diagnosis for reasons of privacy around medical records in Australia all contribute to making the situation worse. So to summarize at this point, the justice system is a highly complex environment, staffed with experts and characterized by language and terminology not used outside of the legal system. And this can be challenging for anyone to understand. But if you have a disability that impacts your cognitive functioning, these are additional difficulties, as I just outlined. Importantly, if the accused have not received an official diagnosis of their disability, the risk of miscommunication and miscarriage of justice increases significantly. And it is important to remember that most cognitive deficits due to neurodisabilities are often invisible. This invisibility, combined with error of attribution that assume communication challenges, reflects a flaw in character rather than a deficit in cognition. This contributes to the revolving door of prisons. These people might be arrested more often for behavior that are interpreted as something else, such as being drunk and disorderly. They're less likely to ask for legal representation in police interviews. They might react in a way that police interprets as aggressive or dismissive, which in turn reduces the likelihood that they will be released on bail, less likely to understand legal instructions from the lawyer once in court, and so on. Partial and possible solutions then, which I guess is what we're all looking for in these 2 days. In Victoria, the state where Melbourne is located for the international audience, there are currently 2 initiatives that seem to work quite well when dealing with people in court who present with complex and intersectional problems like neurodisability, mental illness, addiction and homelessness, and so on. Court Integrated Services Program, or KISP for short, is one of them. It runs from the mainstream magistrates court. It provides case-managed individual support for persons on bail, including neuropsychological screening and assessment and referral to appropriate services. For people with more complex needs, some locations of the magistrates court run the so-called assessment and referral court, or the ARC list for short. The ARC list is a pre-sentence program that specifically supports people with a mental illness or cognitive impairment to encourage desistance and referral into treatment. Clients receive coordinated services in accordance with individual needs, and a support plan developed in collaboration with participants and expert assistants, both in the community and in clinical and case management teams. Participants have described the assessment and referral court as one of the most effective court responses currently available in Victoria for supporting defendants suspected of having or diagnosed with an ABI or other neurodisability. Both police, prosecutors and lawyers highlighted the program's significant benefits, including the view that magistrates involved in the ARC list had higher levels of understanding around ABI than those in mainstream court division. In addition, the structure of the program itself provided greater support and flexibility for clients with ABI to comply with program requirements. The main challenge, and of course there are some, is that spaces are limited on both these initiatives due to funding and also due to a lack of or a high overturn in terms of community organizations and support programs. For people with FASD in particular, there have been other support measures implemented internationally, seemingly with some success, such as the use of intermediaries or communication assistants. This involves an impartial officer of the court often with a speech pathology background, being engaged to facilitate legal proceedings which involves witnesses or defendants with complex communication needs. While the use of intermediaries is currently sporadic across Australia, the Law Council of Australia has recommended that they should be widely available. The main challenge is one around appropriate and timely diagnosis. Without such a diagnosis, support may not be made available, which leads to the next point. The more general issues is that there need to be a better funding for community services and support outside the court and the criminal justice system. There also need to be significant reform in other parts of the criminal justice system: police, community corrections, prison, reintegration services, and so on. For reforms in court, a more integrated approach is needed. Importantly, it should be grounded, I would argue, in therapeutic jurisprudence and human rights, designed with voices of people with lived experiences of ABI and other neurodisability at the center. Such reform should aim to provide timely, individualized, and targeted interventions and support. For these to have effect, better and more targeted training is needed for professional staff who work across the criminal justice system, so that the court is not the only place where these issues can be addressed, but which ensure a more informed and appropriate response from the first police interaction to post-release orders. Many of these behaviors have been criminalized, but for people who do not have a choice but to behave this way, this is inherently unjust. A punitive response inevitably leads to more and longer involvement in the criminal justice system, effectively trapping these people in a system that's not fit for purpose and by extension criminalizes disability. To conclude, the issues around ABI and other neurodisabilities, why and how people get them and their resulting behaviors and challenges might be very similar across countries, but the way they are responded to would most likely differ. Overall, I want to argue for a less punitive approach to this cohort in favor of one that tries to understand and appropriately respond to individual circumstances of people that come to the attention of the criminal justice system. And that's all I have. I have further readings that we can send through to anyone who's interested. Otherwise, I'm very happy to take any questions or any discussions.
Thank you. Thank you so much for that, Anna. That was really good to listen to. Thank you. I totally agree. I mean, reform is clearly necessary, speaking from a neurodivergent perspective myself. And we've started talking a lot about neurotypical privilege, where actually neurotypicals has a privilege in society that's set up for neurotypicals, and we are sort of suffering under that. And I think it's not well understood just how much that setup is actually impacting how we can function as equal citizens. So thank you very much for this. So there is a question in the Q&A from David Quichon. There are major problems like this in England. So how will this ever change and when? That's a very open question.
Well, if I could not only answer but also make it happen, that would be fantastic. I think information is key, and the way, I mean, as we know, especially in kind of Anglophone countries or in general, crime is politicized in some, or responses to crime, and people are labeled for all the wrong reasons in these ways. The way I have approached any communication with Department of Justice politics here in Australia when it comes to reform, and prison is my other big area of research, where it's even harder to argue for change for more humane reason. But that is to focus on long-term community safety. It sounds a bit fluffy, but policy and politicians who run on law and order platform, they always talk about community safety, putting people into prison for community safety, keeping the community safe, yeah? For me, that's a very short-term solution, but to use in the same terms as they do makes them more receptible, I think, to the argument. So to argue for long-term community safety means that, one, preventing people from committing crimes in the first place by supporting them appropriately, but also them meeting their needs to help them reduce their reoffending for their long-term community, other people's long-term community safety. That is the kind of approach I've been using, and it seems to be, they seem to be more receptive than to hearing, okay, so how can we do this? Yeah, and I think courts and magistrates in particular have, the knowledge they have is extraordinary. I mean, I met some amazing people who are driving reform here in Victoria in particular around cognitive and neurodisability, and also around family violence and drug courts, where they see the system from all the different angles. So if you have some magistrates that are keen, get them on board and help them lead the change, I think.
Thank you so much for that. There are other questions coming in. So please, can you share any FASD specific training you're aware of?
Yes, I can't do too much of that. I will refer you to the people who do that. So we published a book, and I'm happy to, if you email me, I can send you a chapter. Shouldn't say that out loud, but we did a whole book on neurodisability and criminal responses, and we had chapters on FASD here in Australia, and there are people who are experts in that area. So if you email me, I'm very happy to pass on any resources that I have.
I'm thinking, how do they get your email?
It's on my final slide. Sorry, it's Anna Eriksson at monash.edu.
Excellent. Thank you so much. Thank you. So here's another. That was one question around, would it be possible to connect with you? And yes, if people use your email as on the slide. So
I'll put it in the chat. So
fantastic. Thank you so much. So which countries offer different services in legal systems for ABIs, and how? That's another very broad question that you might not.
Yeah, because it differs so widely. So in the national research we did, some like Victoria here, they do offer specific things. Most places offer nothing that it's particular. Yeah, it falls under complex cases, or it might be particular legal principles depending on if you're in the UK or in the US, for example. So it will differ. So I don't have a clear answer to that, I'm sorry.
Do you think some of this should try to, on a global level, be pulled together? I mean, this is obviously what we're trying to do here, that we all learn from each other across the different countries. Is there any function whereby that could be pulled together? I mean, obviously, ION will try to do that, but are there any other organizations that are trying to pull together what works and what doesn't work? Because different countries do. So I'm from Denmark originally. We do different things again, and we can learn from each other, right?
Yes, yes, I agree. I'm from Sweden region. That's home for me, and they do things differently too. I think forums like this are really important, and I think even having some kind of online presence or hub where people can find the latest research that also involves lived experiences, because it's quite siloed, I think, depending on if you're in a university environment for the research or if you're in the public sector, for example. So I'll start looking at the chat because it's distracting. I think, I mean, for me, in all the kind of work that I do, one of the key things, that just makes me angry all the time, is this kind of criminalization, I think, of poverty and disadvantage. Yeah. And neurodisability often intersects with that. Of course, it intersects with people who have money, but they don't get stuck in the system because they can afford legal representation and they have other pathways. Like there is a real distinct difference, and especially in Anglophone countries around this. So again, it's about, do we really want to reduce reoffending? Is that what we really want to do? Or do we just want to punish people? If you want to reduce reoffending, we need to think differently. I think another take on that is what Norway has been doing. And I know that's often, put as an example, but for their prison system and how they train staff, and the aim of the system, apart from the normal stuff, is to release people who can be your neighbor. And it sounds a bit fluffy, I think, even for people down here, but I think it for me resonates quite strongly, and it means that if you want to release people who can be your neighbor, we all know who would like us our neighbor as opposed to who we might end up next to, but that then means we have to treat people in particular ways inside the system. And currently we're not producing neighbors, we're producing reoffenders and people who end up as addicts or commit suicide within short periods of time. Yeah. So it's about, I mean, it's all about addressing inequality, but we can't do all of that today. But
we're working with a company called Genius Within sometimes, and they wrote to me. I just want to read out that they have a neurodivergent team who've been working in prisons for the last 7 years. They have achieved 110% contract success on placing neurodivergent ex-offenders into work on release with a 95% sustainability rate. They have a manager that's finishing a PhD and supporting neurodivergent people who were incarcerated with mental health and rehabilitation. I think it's this, isn't it? After the aftercare, you cannot just lock people up and then, I mean, even during lockdown, so I was like, we were all sort of locked down for a couple of years. It was very stressful for me to come back out. I was just a couple of weeks ago and I ended up feeling very overwhelmed. So yeah, we must have that support after.
Yeah, incredibly important. And I was the same. I'm a hardcore introvert. I'm very happy here, and and Melbourne was locked down for a long time, and I still haven't emerged back, but I'm quite happy in here, I think, so that's fine. I think the individualist support, but also support that begins before release. And I've worked with a couple of social enterprises here in Melbourne, and also with some colleagues in Italy through Lend-Lease, who have support programs for prisoners, where the support begins inside prison, preferably 6 months prior to release. Yeah. So you can meet people, you set up the support inside, so having the same contact person all the way through, so you don't shift between organizations, which is confusing for anyone, yeah. And then help them set up work, obviously stable accommodation. Those key things are absolutely crucial. And then a really structured kind of environment, but it has to be, especially around ABI and all these things, individually tailored. People have different needs, and we need to recognize those.
But also community, have some kind of community that can connect into, because you lose that, right? And this is, again, hopefully we can try to bring more neurodivergent people together, but also have neurodivergent people who give support to other neurodivergent people who are offenders potentially, because there are some research around, I mean, it's easier for us to talk to each other, but when you talk to different neurotypes, it becomes more difficult, so the conversation doesn't quite match. And I think that's important. To try to involve us as much as possible in that aftercare work.
Yes, and it removes a barrier, yeah, that you have the same, that you're talking about the same thing and you have similar experience to a degree. You don't have to explain yourself to someone who has no idea how your brain functions. And it removes a barrier to justice and access to justice. That's really, really important.
That's right. Thank you. So someone is asking a bit about neurotypical privilege that I brought out. It's very new that we started talking about that, and we haven't really got any specific research into this, but it will be coming, because it's becoming clear that there are different languages popping up, and we want to explore how that works and works against us and can work for us if we get the narrative shifted. So another question.
I think the point to make, though, just there, I think, and especially around people who end up in prison, privilege is a word I would not associate with most of those people in any way, because of the often socioeconomic disadvantage, poverty, background in trauma, victimization across the board. Yeah, they're the people who are privileged in terms of neurological functioning, but above all with money. It's a money and access and power that dictates the outcomes of the justice system. That it's not just at all. Yeah, it's incredibly unequal. So I think the privilege falls differently once you become embroiled in that. It's a privilege that gets you out of it very quickly. And that has to do with, obviously, level of communication, but also access to those resources, which people may or may not have. So it's an intersection, I think, between poverty and kind of social networks that plays a major role.
Yeah, absolutely. And if we could provide some of that, it might be easier. So we have another one saying here, what about police brutality? Any comments? And I like bringing that up because it's important. I mean, one of my friends is a young Black neurodivergent man, and he got stopped because the way he cycles his bike is different, right? And then when questioned and overwhelmed by two big policemen, he got like just uncomfortable and couldn't, and then you don't look into people's eyes, all of these kind of things happen. He ended up on the floor being manhandled, right? I mean, literally all he had done was driving his bike in the street. This was in London, and then ended up attacked in that kind of way, which will make him uncomfortable and potentially reduce his quality of life from ever going out again, right?
Of course.
So do you have any comments on that, on general police brutality, and how we can have this awareness that when you have a very big sensory band, that's totally overwhelming?
I think, well, a lot of people we spoke to here in Australia had very similar experiences, and I think one of the articles we published, how there's a title that said, "I'm not drunk, I have an ABI," and someone who was arrested because he walked funny, yeah, so he looked drunk and he couldn't communicate. He was slurred speech, yeah, so you're in the drunk tank and on it goes. I think the term police brutality is not helpful. And I'm thinking now with a justice cap on, because the police are very defensive of the organizations and their practice. It's really hard to change.
Yeah.
And I think police would say, and I know they would say, this is not brutality, we were just doing our job, yeah? But it has to change. Responses like that are unacceptable. And it's about education of police. And I know that we are doing, at Monash, we actually, this is promoting now, but we're starting a new degree this year, it's going to develop, where we're having a Bachelor of Criminology, but we're now working with the Victoria Police. So some people who are interested, they will do the bachelor with us for 2 years and then go into the police college. And then we have particular modules that we will teach them. And one of them that I'm writing is around this. So it's a way to educate our next generation of police how to deal with people who don't behave like they do. Yeah, that people from a range of different kind of backgrounds and things. So education is the only way forward. Yeah.
I have in my notes, training. It should be compulsory, but also if we believe in statistics that says that 85% of us are unemployed, then actually there's a very large population of us that we can draw on to train other people or be reverse mentors to, or whatever it takes in size, in scale, to actually move this on and get people understanding differences and accepting it, that we are different, but we are all human beings. On that note,
and I think it's the third, Charlotte, to have training done by people who are neurodivergent themselves, because there's so much misunderstanding around these things and so much prejudice, I think. So it's not helpful to having, me coming and talking to police. We need someone else who does speak and look different, or not different in the way that police would normally react
the whole thing.
Yes, and the police like, okay, this is such a normal person who just speaks differently than I do. Like it's those kind of experience are really, really important. And then the whole police, that's a different conversation.
Thank you so much for your time and for your speech. Much appreciated. We've loved having you here. We have many great, I hope you managed to see some of the comments in the chat. So it's good to stir conversation and stir thinking, and then we keep pushing to change. So thank you so much for being here, Anna.
Thank you so much, Charlotte. I really appreciate it. Everyone who had questions and comments, I'll read through now and make some notes, and then please email me if you need further information. I'm very happy to help in any way I can.
Fantastic. Thank you so much. Thank you very much. Now we will move to the next, if I can get this screen to work, speaker, which is Dr. Kim Turner from Manchester Metropolitan University. And he's going to speak about language and the criminal justice system. And Dr. Kim Turner is a senior lecturer in the Faculty of Health and Education at Manchester Metropolitan University. She's a qualified speech and language therapist with over 15 years clinical experience in the fields of mental health and criminal justice. Kim is passionate about supporting those with speech, language, and communication needs to have equity to access to justice and rehabilitation. She's worked with the government, Royal College of Speech and Language Therapists, NICE, and many others to develop resources and standards in this area. Welcome today, Kim. We are very, very happy to have you here.
Thanks, Charlotte. Just get my screen up. Apologies if I drop out. My Zoom seems very unstable this morning. I've already been kicked out twice. So if I do drop out, it's been coming back within a minute, but please do bear with me. Okay, so just to check that you can see my screen now.
Okay. Yes.
Lovely. Okay, so I'm not going to do an introduction because Charlotte has very kindly already introduced me. So the goal of my presentation today is to explain what speech language communication needs are, convince you, and I think I've already got a very willing audience here, about why these are so important in the criminal justice system, then looking very briefly at each area of the criminal justice process about why speech language communication needs are so important, and then finally finishing with some support strategies, places to go for more knowledge and information. So I'm giving a really broad overview of this today, because I've only got 20 minutes. And also this is from the viewpoint of a speech and language therapist. So I'm aware there are lots of other talks looking at language. I'm really interested to hear Dr. Lalini's talk later this morning on language disorders from a different perspective, but I will be giving my perspective from that of a speech and language therapist who's worked, they generally haven't let me out into the community. I've worked in the custodial setting for the last 15 years. So that's generally where my knowledge and experience is, although I have done work in other arenas. So speech, language and communication needs, SLCN, is a term that we're increasingly hearing in a criminal justice context. So it's an umbrella term that encompasses so much. So there are two main areas when it comes to speech, language and communication needs. There are those developmental needs, so originating in childhood and then persisting through the lifespan. Often, even if they are resolved early on, the impact carries on through the lifespan. And then there are acquired disorders. I'm going to focus today on the developmental disorders, but I just wanted to touch on those acquired disorders, those that language skills are typically developing, and then something interrupts that development in later life. So an example would be a head injury or stroke or dementia. The reason I just wanted to touch on this is across Europe, I know we've got more international audience than just Europe, but I don't know the figures in the rest of the world. We have an increasing number of over 60s in contact with the criminal justice system. In older adults, we are likely, as a cross-section of the community, to see more of these acquired disorders. So we are likely to have individuals who've previously had good communication skills who are acquiring difficulties, and that comes with a whole other set of complexities. Also head injuries. So I know that was spoken about in the previous talk. There is a huge number of individuals in the criminal justice system who've had a head injury. So they might have a developmental language disorder. And then on top of that, have also had a head injury, and then they've got even more complex language and communication needs. So as I said, we're going to focus on those developmental ones. So the developmental speech, language and communication needs that people are most familiar with are those secondary developmental conditions. So those with links to other conditions. So the terms learning disability, autism, ADHD, they're generally, even if they're not well understood, they're heard of, people know them, and people may well be aware that individuals with a learning disability, with autism, with ADHD may well have SLCN. The group that really get very little attention are those with primary speech, language and communication needs. So developmental language disorder is a really common developmental disorder. The figures suggest that 2 children in every classroom will have DLD, and yet it's not really spoken about and well understood. So there are a large number of speech, language and communication needs. I think where we often fall down is there's so many labels, and it's really hard for people to keep track of all of these. And the reason we need to be thinking about these is that the impact of speech, language and communication needs is huge. So in the first few years of life, we're developing our communication skills. And then when we go into school, in those first couple of years at school, we are learning to read. And oral language is the foundations for being able to develop those literacy skills. And after those first couple of years in school of learning to read, we transfer to reading to learn. And for individuals with speech, language and communication needs and literacy difficulties, they find it hard to make that transition, and they may well become further and further behind because their reading skills are not good enough that they can keep up with their learning, and their educational attainment may well be adversely impacted. We know individuals with SLCN have higher levels of mental health difficulties than the wider population. They're less likely to be in full-time employment and less likely to have high income employment, and they're less likely to have those long-term stable relationships. And we know employability in that long-term stable relationships, those supportive networks, are two key factors when it comes to staying out of the criminal justice system. So what we're finding in the last 20 years is that those with SLCN are more likely to have contact with the criminal justice system. So in the general population, we're looking around 6% of individuals who have SLCN. But in the criminal justice population, this skyrockets to over 50%. So that Anderson paper is a systematic review of international studies, and they found it was pretty consistent. What is really important, and I think it was touched upon earlier, is that although we have these really high numbers, around 3/4 of those individuals have not been identified before they've had contact with the criminal justice system. So it's not as simple as asking an individual, do you have SLCN? They may have been diagnosed with autism or ADHD, but they might not be aware. If you ask, do you have language difficulties? They might not recognize that, but most likely they've not been diagnosed at all, and they might not be aware of those language needs. So often I've worked with individuals when they have got a diagnosis within the criminal justice system, and they've said, oh, I knew I found things difficult, but I just didn't know why. And then having that diagnosis has helped them to understand, and then we've been able to put strategies in place. But we can't just ask, do you have difficulties? It doesn't work. And the reason that SLCN is so important in the criminal justice system is that the system is so complex and it is largely verbally mediated. You need really good language skills. You need to understand the questions that people are asking, what they're saying to you, and you need to be able to convey your point of view, your story, and that can cause difficulties at every step. And what I'm going to do now is a whistle-stop tour through each of those steps to highlight just some of those difficulties and some of those emerging supports that we're now seeing. So often the first contact with the police would be being cautioned. So this is research based on the UK caution, and Fenner and colleagues asked, do you understand the police caution? And when they asked, 96% of people said they understood. But then when they probed further and asked about the concepts within the caution, it was actually just over 10% that actually understood that caution. We can't ask, do you understand? One, the right answer there is yes. Societally, that's the right answer. If somebody in power asks you that, the right answer is yes, whether you do or not. It's embarrassing to say no. You may not be aware that you don't understand. That power imbalance, the stress, it just doesn't work as a question. We need to delve below that and ask real questions to check understanding rather than do you understand. And then with the police, again, you have to understand those charges. So sadly, as I said, I worked in a custodial setting. I'd be seeing individuals who'd been through the court system and are in custody. And at that point, they're asking me, what did that charge actually mean? How can it be right that an individual has gone all the way through the system and still doesn't understand what they were charged with? And then obviously highly verbally mediated, engaging with that interview. So there has been a lot of progress in the last 20 years. I'm speaking mainly from a UK context, well, England and Wales context, because that's where I am. And there is now support around for vulnerable individuals, and there is an onus on police and legal advisors to identify individuals who are vulnerable and require additional support. And it's brilliant. SLCN is recognised as a potential vulnerability, but the police and legal advisors, they're not experts in speech, language and communication needs. They haven't necessarily had training. They don't have a tool to identify SLCN. So how are we expecting them to recognise who is vulnerable, who would benefit from support without that? There is some great work going on at the moment, and I'm aware that Donna is speaking later today in the police session at 2 p.m. about some work going on in liaison and diversion services to screen for speech, language, communication needs at that point. And there is the appropriate adult service, and I know Roxanna in the next session will be talking about that. An issue with the appropriate adult service in England and Wales at the moment. So if the police and legal advisors are able to identify that individual with SLCN as vulnerable, they're able to ask and get that support from an appropriate adult. Unfortunately, at the moment, you don't have to have skills and training in supporting individuals with SLCN to act as their appropriate adult. So in the last couple of years, that has changed in Scotland. So they've now changed it for appropriate adults, that you have to have experience of the needs that you are supporting that individual with. And I think that would be great to see that moved forward to England, Wales and across the world. So moving now to the courtroom, again, we're talking about the English and Welsh system, but I know lots of court systems around the world have this adversarial system. There is a lot of archaic language that is only used within the courtroom, really complex questions, statements posed as questions. It's really, really hard to follow. I know as a 16-year-old on work experience, I went to visit a courtroom and I sat there throughout a whole court case. And at the end of it, I really didn't know what had happened. And I was a supposedly educated student with good language skills, but I was unable to navigate that language. It's an unfamiliar environment. There are people in unfamiliar roles. What is an usher in this situation? What is the role of the jury, the magistrates, the judge? And it's a really stressful environment. So it may be that an individual has speech language communication needs. They're just about able to get by normally, but then that stress of the court environment is layered on top, and that tips it over. So there is an onus on us as professionals to adapt our language. There is some really good support out there from intermediaries and some information on the Advocates Gateway about how to support language. Charlotte, I'm aware that I'm overrunning and I'm going to wrap up really quickly.
Thank you.
So in custody, again, it's really hard to navigate the system, benefit from rehabilitation without having the language skills to do it. So when they looked at a study of rehabilitation programs in English prisons, they looked at the language level in those, and they were at A to C level equivalent at GCSE English. Now, having worked in a prison setting for 15 years, I can probably count on one hand the number of individuals who had achieved an A to C GCSE in English. So there's this mismatch between where those rehabilitation programs are aimed and the language skills of those individuals in the system. Thankfully, Maxine got a session. Maxine Winstanley has got a session tomorrow in the probation slot to talk about young people with developmental language disorders in community settings. What we do know is that young people with language disorders were more likely to reoffend than their peers, even when you accounted for other factors. So 2 of the biggest protective factors against reoffending: employment and those family and friendship networks. Both of those require significant language and communication skills. We need to be supporting those speech language communication skills to provide equity and access to justice. I know the title of the conference is about equality, but I think we need equity and access. And also to support access to those alternative positive life choices. So we all need to be aware of those speech language communication needs and have strategies to support, and also understand when that is beyond our skill level and we need to refer on. So the final slide is just some links to strategies to support training programs that you may find helpful, and links to some of those specialist individuals. And sorry for overrunning.
It's okay. Thank you so much for this. This was very insightful. Thank you. We've got 7 minutes for some questions, and we have a few questions, but from my point of view, language matters. So English is my second language. When I came here in 91, you've got to learn, and that's the case for many people. But not only that, I do feel that we should, again, use much more intermediaries, as you talked about, but neurodivergent mediators or experts who understand, because we know what it looks like on our side, right? And it will be a lot easier to connect, and it would be a brilliant way to create more jobs as well for neurodivergent people who could be part of making it easier for everyone and reducing the cost for governments of having people incarcerated, because what we do want is people in work, thriving and functioning as full citizens, right? So anyway, going to some of the questions. So David is asking, have you ever been successful in stopping a major prosecution case on the basis of SLCM once it has been sent to court, to County or High Court for trial?
So that is not my area. So I have advocated for individuals. So from a custodial setting, I have seen individuals who've been on remand in that custodial setting, recognised their speech language communication needs and advocated for them to have that intermediary support, talked about capacity as well. But there's a really high threshold when it comes to court, an individual being deemed to lack capacity to be able to go through with that court proceedings. We've had individuals where their mental health has been such that it just was not fair or possible for them to engage with that courtroom, and the psychiatrist is saying that that's not okay, the psychologist is saying that's not okay, we're saying that's not okay as allied health professionals, and it's gone ahead. So that bar is really high, and a lot of the time it's very dependent on who the judge is and what their view is about supporting individuals. So we've worked with some barristers, QCs, who've really got it and really understand the value and benefit and the fact that this can save a huge amount of money, that it's not going to an appeal afterwards, because it has been a fair process where everyone has had access, fair access to the system. Equal but it really does depend on understanding.
It does, thank you so much. I mean, really, I heard of someone, I spoke to someone who had been in the legal system and who had to explain to the judge what neurodiversity was. It was kind of hard if the judge is judging your case. And then secondary also had to explain about autism. It was not understood by the people judging the case. That's not acceptable, right? At all. So I think that we need some work there. So there's another question around, should police be assessed to see if they can identify vulnerable people accurately, or even as well as the public?
I think we need to support the police to be able to identify vulnerable individuals. I don't think we can expect the police to be experts in neurodiversity, mental health, speech language communication needs, everything else. That's not their remit. However, if the onus is on them and legal advisors to identify vulnerability, we need to be supporting them in order to do that. So whether that's a screening tool, whether that's through liaison and diversion services, embedding individuals from a healthcare background within the police station to support the police to screen. But yeah, we need to find a way that it's great. In the last 20 years, provision has massively increased. We are recognizing these needs more, but so much is being put in place. So when I first started working in YOI in 2010, there was no screening for neurodiversity, speech language communication needs. In 2016, we got systematic screening, which is great, but that is delivered by healthcare professionals who don't necessarily have training around neurodiversity, neurodisability themselves. So training, creating support's great, but then providing the training so people can identify those individuals that need that support and can provide that support. I think that's so important. It needs to be part of the package.
Really.
I know it's expensive.
Yeah, so screening comes up again and again, and I think there is something to be said for having a conference on what should this screening be. Is there a way to create a universal way where we can capture, you know, a broad range of neurodifferences within a tool, and that we can then work from in terms of then helping the people? You know, there's so much to do, but we need to start somewhere. So
Yeah.
we've at the end of it, there is one last question. Does this system not reflect the social services system of conferences with high language needs? I'm not sure I fully understand that question.
No, me neither.
But if we just go, does this system not reflect the social services system? I would say it does, because everywhere, this is not just, we are focusing on the legal justice system here, but what we find is it's everywhere in society that we are having these difficulties. And I think there are some universal ways we can broaden how we embrace a broader group of people. And we need to look to them for the broader society as well, not just in here. So I think the difficulties we experience in one system, we also, I experienced severe difficulties in school. I know someone who's high above average intelligent, and the teacher said, we can't teach this person anything. So the person taught themselves to read, but actually it should have been the school, right? And that was not, the intellect was not there. It's because the learning difference, it couldn't be captured within school.
Yeah, so, and I think early intervention and investing in that early intervention and teacher training. So teacher training, I assumed teachers learn about neurodiversity and atypical language development. Looking at the syllabus for teacher training in England, they don't learn about typical language development, let alone atypical language development. So yes, we need more understanding across the board and earlier intervention to prevent individuals coming in wherever possible.
Thank you so much. Thank you so much, Kim, for being here. We really appreciate your time and your insights and sharing your knowledge with all of us. Thank you very much. Thank you all. We will move to our next speaker, which is Dr. Roxanna, and I'm very sorry if I mispronounced the surname, Dr. Roxanna Fatemi-Dehaghanir from Cardiff University, Neurodiverse. The title of it is Neurodiverse Suspects Vulnerability and the Appropriate Adult Safeguards. Dr. Roxanna is a senior lecturer in law at Cardiff University, where she researches how law, policy, and practice can improve the experiences of vulnerable people who encounter the criminal justice system. She has published widely on criminal legal aid and access to justice and vulnerable suspects, including in the Oxford Journal of Legal Studies, the Modern Law Review, and Social and Legal Studies. Her first book, Vulnerability in Police Custody, was published in 2019, and her second book, Experiences of Criminal Justice, was published in 2022. She sits on the editorial boards of the Hard Journal of Crime and Justice and the Journal of Adult Protection, and she's currently lead editor on Vulnerability, the Accused and Criminal Justice System. Thank you very much, and welcome, Dr. Roxanna, to our conference.
Thank you. Good morning, everyone. Though it's very difficult to pronounce my name, I usually just use the last part. No one, unless you speak Farsi, I doubt you'll be able to pronounce it properly. I can barely pronounce it properly, and I've had this name for 33 years. So
we have really interesting Danish names as well that are slightly difficult outside of Denmark. So yeah.
Can everyone see my screen?
Yes.
Yeah. Okay. Good morning, everyone. Just a caveat in that this presentation is slightly different from what I had sort of envisaged presenting. I am going to focus on autism. Partly the reason for doing so is you might see through the analysis that if I was to look at neurodiversity as a whole, I probably would not be able to complete this talk in 20 minutes. So I'm going to focus on autism. There'll be certainly things I think here that other people are already aware of. So apologies if I'm sort of covering material that is already kind of widely known. I'm going to be looking at vulnerability and the appropriate adult safeguard. Now, this is a safeguard that exists in England and Wales. Under a similar framework, it also exists in Northern Ireland. And there are, I think Kim sort of briefly touched upon it, there is also an appropriate adult safeguard in Scotland, although that safeguard is also applicable to victims and witnesses. And I don't know an awful lot about the Scottish system, although I'm in the process of learning a lot more about it. So what I'm going to look at is the general challenges around identifying vulnerability, defining vulnerability, and general challenges around the appropriate adult safeguard before I drill into more detail around the specific challenges that autistic suspects may face. And the question is, of what more can be done to support, to better support autistic suspects in police custody. Now, these are just initial thoughts. So I am very welcome or very grateful to kind of receive any feedback. So I think most people I'd say in this room will know the types of things that autistic people may struggle with. So this talk is obviously going to be largely focused on deficits, because I'm focusing on what, how we can address those deficits, but just to acknowledge that there are also many strengths that autistic people also possess. So a number of things that autistic individuals may struggle with: difficulty communicating and interacting with others, struggling to understand how people may think or feel, overwhelm, distress, discomfort, so kind of sensory issues, anxiety or upset when in unfamiliar situations, taking longer to understand information, and displaying repetitive behaviour or thoughts. And some of these are important in terms of the analysis that I'm going to provide a bit later. So just briefly, there is emerging research in this area. I think the research is still kind of relatively in its infancy. I've mentioned on this slide a couple of researchers in England and Wales whose research is really important in this area. Tom Smith at the University of West England is also conducting research around neurodiversity in the criminal justice system. So I predominantly draw a little bit upon Chloe Holloway's research. Chloe looks at problems in police custody for autistic individuals, and she's done some really innovative work on the experiences of autistic individuals in police custody. Cooper and Aleli then, so I know Penny Cooper will be presenting later on today, they have examined criminal justice professionals' perceptions of autism. So in particular, the ways in which judges might interpret an autistic person's behaviour and the problems that therefore may arise in terms of their kind of effective participation and fair trial rights. And there were kind of two, I think, overarching themes that emerged from these two pieces of research. One was the need for accessible information provided to autistic individuals, and that information, there isn't necessarily information, there is information, a lot of information provided to suspects when detained in police custody, but that isn't necessarily accessible information or information that everyone can necessarily understand. And indeed, within the context of the legal sphere, the criminal justice sphere, there's a lot of language that is used, and Kim has touched upon that, language that is used that is difficult, I think, even for adults that are neurotypical to understand, but also, even as a lawyer myself with a legal background, there are things that sometimes I struggle to wrap my head around. And Cooper and Aleli also highlighted then the greater need for information and knowledge required amongst criminal justice professionals. So this awareness raising, it's necessary for criminal justice professionals to understand autism or other types of neurodiversity and how that might impact upon an individual's participation in the process. So I'm going to focus here predominantly on the appropriate adult safeguard, and it is found in Code C to the Police and Criminal Evidence Act. So the Police and Criminal Evidence Act, for those that are not familiar with the provisions in England and Wales, was introduced in 1984, but it came into force in 1986, and it addresses the powers of the police. Now, the Police and Criminal Evidence Act itself doesn't actually cover these vulnerability provisions. It's found in Code C, which relates to your detention of individuals. So this is typically in a detained interview setting, for example, when someone's brought into police detention and is processed for the purposes of the investigation. Those that are considered vulnerable are either under the age of 18 or have a mental health condition and or mental disorder and meet the requirements of the functional test. And I'm just going to explain what the functional test is in a moment. Code C doesn't actually really give us much information about the identification of vulnerability. It focuses predominantly on risk, namely physical risks, the physical risk that that person may pose to others, but the physical risk that may be posed to them whilst in police custody. There is some information on the College of Policing's authorised professional practice, but again, this is somewhat scant, and there are notable problems with the identification of vulnerability, namely that the questions on the risk assessment, which is carried out at the beginning, typically, of the detention process, does not usually ask any questions that might enable someone to identify or to kind of self-disclose information around, for example, vulnerability or neurodiversity. The appropriate adult safeguard, I think Kim briefly mentioned the appropriate adult. The appropriate adult is there to support, assist and advise, to facilitate communication, uphold fairness, rights and entitlements, and ensure that an individual's rights are understood by that individual. And there are various individuals that can perform that role. They can be volunteers or professionals. They may have training. They could also be relatives, guardians, anyone over 18, potentially without training. Now, the benefit, and I've covered this in a 2022 paper in the Oxford Journal of Legal Studies, the benefit of having someone who's known to the individual is that they will know a lot more about the individual, but they may not know about the legal processes and so on. Then obviously the drawbacks of having the benefit of having someone professional or someone trained is that they will know the legal requirements and so on and so forth, but may not know enough about that individual to be able to kind of appropriately adjust that process. Okay, so I did mention the functional test. This is essentially what the functional test involves. So an individual who may struggle to understand or communicate effectively regarding the implications of various procedures and processes connected with their arrest and detention, their voluntary attendance, or their rights and entitlements and the exercise thereof. They may not appear to understand the significance of what they are told, questions asked, or their replies, or may be prone to becoming confused or unclear about their position, agreeing to the suggestions of others without protest or question, or without knowing or wishing to do so, providing unreliable, misleading, or incriminating information, or accepting or acting on suggestions from others. So this is largely kind of influenced by the psychology and law literature around why individuals, for example, may be unable to effectively participate in an interview. And I think the important thing is to recognise is that the interview is part of a process, and therefore it's not simply that safeguard is required for the interview, but it is required for typically the duration of that detention, but particularly the kind of the key legal aspects within that process. Now, there's some general problems around the provisions on vulnerability. First, for adults, it's contained in soft law, as I mentioned, Code C. For children, it is contained within statute under, I think it's the Crime and Disorder Act, and I forget, but that requires that youth offending teams in a situation where an appropriate adult is not available for a child. So, for example, a family member is not available to attend, that youth offending teams will attend as an appropriate adult. So it places that on a statutory footing for children, but it doesn't exist in that case for adults. One of my critiques of the provisions is that it focuses on the reliability of evidence. The way in which it exists in law, and indeed the way in which it works in practice, it largely focuses on whether the evidence is going to be reliable, and that does create some additional challenges. But on a very basic level, it does mean that the focus is not on what the individual requires, but what is required to safeguard the evidence instead. The other challenge in law was that until 2018, when there were significant changes to Code C, there was no acknowledgement of the right to silence. So facilitating communication was one of the elements of the appropriate adult's role, but there wasn't an acknowledgement that this meant the facilitation of the absence of communication, for example. In practice, there are a number of problems with the provisions and with the appropriate adult safeguard itself, and I'm going to go into more detail on the safeguard, I think, in the next slide. So first is the low uptake. Estimations between 3 and 6%. I've worked with Chris Bath of the National Appropriate Adult Network on his There to Help series, which looks at freedom of information requests and examines implementation rates of the appropriate adult safeguard across England and Wales. It's estimated that between 20 and 40% of suspects should receive an appropriate adult based on the conditions that they have, and around 3 to 6% are actually provided with an appropriate adult. There's also some level of interpretative judgment. Now, some people might refer to this as discretion. I like to refer to it more as interpretative judgment. So it's the way in which the police interpret the provisions to decide whether or not someone meets the requirements of those provisions. So they're not necessarily exercising their discretion not to implement the safeguard, but they're interpreting the safeguard in a particular way, which enables them to not apply it to some individuals. There are also problems with the definition of vulnerability. So in practice, it's quite narrow and exclusionary. I don't have time to go into this, but I will give some examples specific to autism later. There are also some face value assumptions. So does the person, quote, present well? What do they appear like when they're in front of me? Do I think they're understanding what I'm saying? If not, they might get an appropriate adult, although again, there have been some surprises when I've been observing in police custody. I was observing for a total of 6 months. Some surprises where even healthcare professionals were not implementing an appropriate adult for someone who very clearly was in distress and didn't understand what was happening. The identification of vulnerability. So I mentioned the risk assessment. The risk assessment is limited. It covers predominantly questions around physical risk. It does ask questions about mental health conditions, but again, it's geared towards risk. And one of the problems with some of the questions is, say, for example, someone does have autism, they might not acknowledge that as a mental health condition or a mental disorder. And there's some debate as to whether it should be considered a mental disorder. So they might not actually self-disclose. So that's one of the ways in which it could be identified as someone saying, I've got schizophrenia, for example, or I've got autism. That information might not be forthcoming for various reasons. One of the other ways in which vulnerability could be identified is through the use of what Hart and Palmer called informants, but informants are not always available. These could include family members, the arresting officer if they have information at the time of the arrest, healthcare professionals, and they do play an important role, but there are also some problems with their role within this decision-making process. The other is that often the appropriate adults, so there's then decisions. So supposing someone is defined as vulnerable and identified as vulnerable, then there may be kind of a third barrier, which is decision making. And that is, one, if there's a solicitor or legal representative, they're seen as effectively the replacement for the appropriate adult safeguard. And I don't have time to critique that, but I have written on that before and critiqued that particular approach. There's also a lack of scrutiny. So if the case is not going to reach the courts at all, most of our cases do not reach the courts, around 80 to 90% of them in England and Wales. Of those that do reach the courts, and the stats are probably even worse so now with post-pandemic or during the pandemic. But of the remaining, say, 10%, the majority of those will go to the magistrate's court, and questions around the reliability of the evidence, for example, may not be asked at the magistrate's court, particularly given that lawyers are increasingly kind of overworked and underpaid, and therefore not going to be sifting through evidence to identify whether the Police and Criminal Evidence Act has been breached, and that there are also problems with how the courts interpret those breaches as well. There are also some general problems with the appropriate adult safeguard. So they facilitate communication, but they lack legal privilege. So they do not destroy legal privilege, but it's very difficult, I think, to get a real grasp on what's happened without having the option of legal privilege for the suspect to be able to be open and honest with the appropriate adult. So there's a question around whether that absence of legal privilege can interfere with the appropriate adult's ability to facilitate communication. They're often only called for interview. They are supposed to be present for a lot of different procedures, but typically for adults at least, they are only called for an interview, which can mean then if someone hasn't understood something before the interview, that could have a bearing on their participation or lack thereof at the interview. One of the key problems, I think, is that they are discouraged from taking an active role. Now, Code C refers to this unreasonable obstruction, that the police can remove someone, an appropriate adult, if they are unreasonably obstructive, but this isn't defined in Code C and it isn't defined in the case law either. So it can mean that an officer can essentially say to someone, you're being unreasonably obstructive, for example, reminding the suspect of their right to silence, and could be ejected from the interview, which places, and I mentioned this here, but that, amongst other things, places the appropriate adult in a difficult position in terms of the power dynamics between them and the police. There are also numerous problems with suitability and availability, so whether they're appropriately trained and on what. The National Appropriate Adult Network does offer training and professional development for appropriate adults, but not every scheme is going to be part of the National Appropriate Adult Network. And indeed, if you've got appropriate adults who are family members, they may not have any of the legal training that or training about the criminal justice system that the those that are professionals and volunteers. There are also issues around availability. So some schemes only operate between daytime hours, sometimes they don't operate at night, and so on and so forth. And crucially, they're addressing multiple vulnerabilities, right? So it's a generic safeguard that is intended to apply to all vulnerable suspects, but that's both children and adults. And then obviously even for adults, there is significant variation in needs. So now I'm going to go on to autism. There were particular challenges, and I wasn't looking at autism specifically, I was looking at the implementation of the appropriate adult safeguard generally, but there were some examples given that discussed autism. And so one example was one officer who said, well, I have a friend, he's autistic, he's very smart, his son's doing languages at Oxford University, they're a little bit strange, they behave a little bit weird, but that doesn't make them different. The Autism Society suggests that everyone with autism have an appropriate adult, but he's arguing, well, you know, my friend's smart, I don't think he needs an appropriate adult. And when asked why, he said they know the difference between right and wrong, they know why they're here. Now, I don't have time to critique this, but I think this is quite a kind of simplistic approach. Okay, they're smart, so that must mean they understand every single thing that is going on in this setting. And it means that they can communicate effectively when under pressure, when isolated, when in an environment that is not particularly conducive to someone's needs, particularly if they are autistic, and Chloe has done some really important work on that area. So one, I think some of the considerations, and I think it is important to acknowledge the kind of nature of police custody. So an individual is going to be isolated, they'll be locked in a cell. The cells, for various reasons, aren't particularly pleasant, as one might appreciate. You won't necessarily know what time it is, whether you might not know whether it's day or night. You won't be able to speak to anybody. You are permitted to have someone informed of your detention, but that doesn't necessarily mean that you're entitled to have a phone call. There is a lack of control. So obviously you're on police territory. You are kind of, your movements are subject to the timescales of the police, the things that the police need to do or want to do. There's a great deal of uncertainty. So uncertainty regarding the length of detention. There are limits regarding the length, but that of course doesn't mean that those limits won't be exceeded for legal reasons. But also uncertainty with regards to the case, uncertainty with regards to what's simply happening. Now, again, some forces may be autism aware and therefore may be able to address some of these issues. But nevertheless, you can think, you know, when detained in a cell by the police, door locked, possibly having had your clothing removed for whatever reason, or not being able to wear your shoes or whatever, not having any control over what you eat. So being given certain, you know, other than meeting dietary needs, you know, not the needs not being necessarily met, and also sensory issues. So as I mentioned, I spent 6 months in police custody. It's not the most, it's not the nicest of environments to be in. There's very bright strip lighting. It's quite stark. The smell is not fantastic. It tends to be kind of vomit, bleach, alcohol, urine, blood. So there are particular sensory issues, I think, that need to be acknowledged here as well. Now, in terms of identifying autism, as I mentioned, there aren't any specific questions on the risk assessment, and there are in some forces additional questions that can be asked if that particular police officer thinks that the person may be vulnerable. Those questions in and of themselves are quite problematic. They ask, for example, did you go to a special school? Well, a lot of people, even if they do have additional learning needs, are going to be schooled in mainstream school. It also asks about telling the time and so on. Again, a number of people would be able to tell the time, but they might not be able to understand their right to silence, for example. So one of the officers said, well, you know, autism is a spectrum, and if someone presents really well and they say I'm autistic and I would have known that they were autistic, well, I wouldn't give them an appropriate adult. They would go straight to interview. Now, this obviously raises questions about masking. So autistic people may perform incredibly well, may seem not to have any worries about the process of their case and so on, may be able to communicate effectively with the officer in the set, with regards to the risk assessment. But we know that there are kind of specific things that autistic people may struggle with, and we know that autistic people do put often a great deal of effort into masking or into kind of assimilating in some way. So that can be a particular challenge. Now, there were 2 officers that noted that anybody with autism would get an appropriate adult because they've been told anybody with autism gets an appropriate adult. It might be the case that a person with autism doesn't need an appropriate adult, but I would say, given the challenges around identifying vulnerability, and I'm just providing some very basic overview here, that's probably a safer approach than trying to identify whether the person really needs an appropriate adult. But importantly, the safeguard is not designed around the needs of autistic suspects, and often appropriate adults will lack understanding and knowledge of autism. So Richard and Milne's research, there was less than 30% had received autism training. 43 out of their 48 respondents had thought that further training would be useful, and they found that appropriate adults could generally recognise some characteristics associated with autism, but there were also some significant misunderstandings, which I don't have time to go into, but if you're interested, I would recommend that you read their paper. Now, there are limitations with their results, the number of appropriate adults in the organisations that have taken part, particularly because there is such diversity in terms of appropriate adult services across England and Wales, both in terms of how they're staffed, whether they're trained, what area they operate in, and so forth. So there are questions around what needs to change. So I have argued that the appropriate adult safeguard needs to be more kind of designed around the needs of suspects. Now, that I think might present some challenges. There definitely are some practical challenges around that, and I think it would in some ways require that the detention process is entirely kind of ripped apart and that we start all over again. And again, I can answer some questions on that if anyone is interested. Structural and cultural change. So improved identification and improved knowledge of autism, I think we've already mentioned that, or has already been mentioned this morning. There need to be clearer definitions in PACE and Code C and/or explicit definitions. So, for example, references to the Autism Act 2009. Now, one of the problems that is emerging now is that the Mental Health Act Code of Practice did include autism as a mental disorder. So it was kind of acknowledged within Code C. It is now, for various reasons, being removed from that definition of mental disorder, which on the one hand is a positive move, on the other hand might interfere with the appropriate adult safeguard and I would argue that the police don't necessarily pay that much attention to Code C, but certainly there may be some challenges there. And I think there needs to be some further research. There is really important research that has already been conducted in this area, but how autistic and neurodiverse suspects generally engage with police custody processes. As I mentioned, Chloe Holloway's done some really important work there. How criminal justice professionals understand autism and neurodiversity. Again, Cooper and Aleli have done some really important work there, but I think more work is needed. There are advantages and disadvantages to each of these, which I don't think I've got time to go into, but I have been whistle stopping it through. So I think the key takeaways, I know I've provided a bit of a whistle stop tour of this, and as I said, I'm very happy to answer any further questions. It's difficult. Vulnerability is difficult to define. It's quite vague. It can be difficult to identify there is guidance on how to do so, but that guidance is either ignored or can be difficult to implement in practice. And Kim did mention, you know, the question of whether we should be requiring police officers to identify vulnerability. Now, I'm working with Chris Bath of the National Appropriate Adult Network, training police officers and liaison and diversion workers, and hopefully also healthcare professionals, to help them understand what vulnerability means, how it could be identified, and why it's important that it is identified. The appropriate adult, I think, is a really important role that doesn't exist in all jurisdictions. I think that some jurisdictions, I think, have at least expressed an interest in implementing something similar. But I do think there needs to be quite a lot of thought given it was introduced in the 1980s. It has kind of evolved, the provisions have evolved somewhat since, but we know so much more about mental health, about neurodiversity, about individuals' abilities to effectively engage with the criminal justice process. And I think, you know, our knowledge has moved on so much in the last 40 years, yet the safeguard still largely exists as it was in the 1980s. I think crucially, it's not designed around the needs of autistic suspects. And I'm not saying that it necessarily should be, but if we are to be, if our focus is on reliability of evidence, it can rate whether the safeguard meets the needs. That can certainly raise questions there, but also I think that the importance should be placed on what the suspect themselves requires. Now, there are reasons as to why the reliability of evidence is important. The police want to safeguard their case, and therefore they're going to introduce this they're going to implement a safeguard so that the case isn't thrown out of court, for example. But I don't think that should be our key focus. Our key focus should be on what individuals require. And there are various reasons, both kind of human rights reasons that we would want to do so, but also very practical reasons that we should do so. Now, I think that police custody practices and the safeguard could be adapted to better support autistic suspects. Again, Chloe's done some really important work in this area. And I think some of these lessons could probably be transferred to neurodiverse suspects more generally. As I said, I haven't provided that analysis of neurodiversity generally, just simply because there is so much to cover. But I think more needs to be done in this area. And part of it may well, as I said, require sort of starting from the very beginning and really thinking about how we can organise the criminal justice process, or this early stage, this really important stage, I should add, in the criminal justice process, given that so few cases actually do reach the courts, that yeah, we probably need to start all over again. The other thing that I haven't touched upon is the role of the United Nations Conventions on the Rights of Persons with Disability and the questions that it throws up in terms of effective communication and participation in this area. So I don't know how long I'm doing for time.
We've at the end of the time, which unfortunately kicks out the questions as we have to go to the next speaker.
Okay, I didn't know that. I didn't see any kind of warning, so apologies for.
No worries at all. Over. I was wondering, there are 4 questions in Q&A. Would you mind typing answers to those questions?
Yeah, no problem.
I can see that. Would that be okay for you?
Yeah, not a problem.
Thank you so much for that. There are lots of things that needs changing, which you're making very clear. And the next step obviously is for us to actually think, how do we make that change happen in real life? What is it we need to actually make it happen? But starting with identifying exactly what is it we would like to see changed, then hopefully we could bring together a powerful coalition that can push for that change. And my experience tells me, if you don't have a sense of urgency for change, then no change will happen. So we have to create also a sense of urgency, which we're hopefully doing, the more our voices will get heard. So thank you so much for being with us, Roxanna. Really, really appreciated your time and your insights, and for being here today with all of us. Thank you so much.
Thank you for the invite. Thank you.